I'm Jeffrey Rosen, the president of the National Constitution Center, and I'm sitting here with Neal Katyal, former acting Solicitor General of the United States. We're here to talk about the Supreme Court, privacy, and technology. There's a third case we should talk about, and that has to do with DNA surveillance. In the Maryland and King case, the Supreme Court, by a divided vote, held that it's okay for the cops, when they arrest you, to swab your cheek, seize a sample of your DNA, and put it in a database. What was the majority's reasoning in that case?
Well, the majority reasoned that when you stop someone for an arrest, you are entitled to collect information about them, that there was a public safety rationale for that. Indeed, the court pointed to the fact that this DNA evidence has been used not predominantly to inculpate someone, to say that they're guilty, but rather to exculpate people, that the information found in these searches tends to show, hey, actually the person we thought did it didn't do it. And so they said, effectively, there is a minimal invasion of privacy. It's just your saliva for a second. And this does something important in the real world. It solves crimes.
Now, there was a vigorous dissenting opinion by Justice Antonin Scalia, who compared these cheek swabs to the hated general warrants that Chief Justice Roberts had invoked in the cell phone case. He had very memorable lines about how our hardy forebears would never have tolerated these royal intrusions into their mouths. What was Justice Scalia concerned about, and what sort of private information did he think could be revealed by these DNA searches?
Well, Justice Scalia's concern is that the government could run amok and use this information in all sorts of ways. Our DNA has any number of markers that suggest what diseases we might have propensity to. There may be ways to use this biological information in other ways and see, what drugs a person has consumed or something like that. So there is the potential for government abuse. Justice Scalia writes an extremely powerful opinion. I think the majority's answer is to say, Justice Scalia, what you're concerned with is not as much about the constitutionality, but the wisdom or the policy behind these searches. And maybe there should be limits placed on them, and the government shouldn't use them willy-nilly, but that's really a choice for the political branches to decide, for law enforcement to decide, and not something we should constitutionalize and take off the table. Because if Justice Scalia's opinion is adopted, even if 100% of the citizens of Maryland want these searches, or 100% of the citizens of the United States, Justice Scalia's position would be, you can't do it no matter what. It's off the table in our democracy.
It is indeed, and then Justice Scalia's counter-argument, of course, is that it was the framers who took off the table the idea of suspicionless searches that are not limited in scope, and DNA searches have the potential to reveal so much about us that they're just as bad as the general warrants that sparked the American Revolution.